Can employer terminate the labor contract with employee due to COVID-19 outbreak? Due to intricate occurrence of COVID-19, many enterprises are forced themselves to reduce the number of employees for maintaining the operation financially. Specifically, the employer has to make difficult decision to terminate the labor contract with the employee. The termination of the labor contract has to be considered carefully because of potential legal risks brought up, which dispute lawyers and labor should be consulted before execution. Within this post, we are not trying to resolve all cases but only aiming to brief some matters of concern for preparation. Within this post, we are not trying to resolve all cases but only aiming to brief some matters of concern for preparation. Force majeure in this case is understood as enemy inflicts destruction, epidemics, relocation, or narrowing of the production and business sites, at the request of competent state agencies. In particular, after applying corrective measures, over the time, considering enterprise's financial potential is insufficient as well as the business production is reduced significantly due to epidemic, the employer may consider unilaterally terminate labor contract with employee. However, employers still have to abide by or ensure the rights to employee regarding the interests which employee is entitled to receive when being unilaterally terminated. Labor contract includes salary, severance allowance, social insurance, payment for and taken leave days, the tax payment which employer must pay for employee. Besides, employer also is subject to pay a compensation if consented by both sides or employer and employee. Firstly, employer is obliged to pay salary to employee timely and fully as in the agreed labor contract by both parties. Firstly, employer is obliged to pay salary to employee timely and fully as in the agreed labor contract by both parties. Thirdly, social insurance. Employer is responsible for the fulfill payment of social insurance and perform the closing insurance book for employee after terminate the labor contract according to the law of social insurance. Fourthly, if the income of employee subject to personal income tax, employer must extract from the income of employee to submit the tax to tax agency according to law on personal income tax. We help clients overcome cultural barriers and achieve their strategic and financial outcomes, while ensuring the best interest rate protection, risk mitigation and regulatory compliance. A&T Lawyers have law firm in Hanoi, law firm in Ho Chi Minh City and law firm in Da Nang.